Here's a fun fact. Each year, there are around 1,000 family provision claims filed in New South Wales alone. Of those 1,000 cases, only about 30 end up at final hearing. That's only 3%. The other 97% settle outside of court. Why is that? Well, in large part, mediation. Hi, I'm Ella Stratford, solicitor on the Contested Wills and Estates team here at Turnbull Hill Lawyers, and I'm going to take you through the benefits of mediation when dealing with wills and estates disputes. Mediation is a popular form of what we call alternative dispute resolution. The process involves the skills of an independent third party, known as the mediator. The mediator is specifically trained to identify sources of stress, promote mutual understanding between parties, and resolve disputes. The mediation process encourages parties to a disagreement to come together and work towards finding a solution that is positive for everyone involved. It's all about the compromise. Now, what are the advantages of mediation? Mediation is a popular form of dispute resolution, and for good reason. Mediation fees are generally much lower than the costs associated with running a dispute to final hearing. Resolution via mediation is often much faster and less stressful than attending a final hearing. Unlike published court decisions that you get with a final hearing, mediation is highly confidential and private. And my personal favourite benefit to mediation is that it encourages compromise. It promotes reaching an outcome that can be seen as mutually beneficial to all parties to the dispute. Now, you're probably thinking, that's fine, Ella, but what does mediation actually look like? What is actually involved? Well, let's quickly run through the process. Private mediation is mediation that has been arranged by the parties. The parties agree upon the location, the date, and the mediator. There's a little bit more flexibility. Alternatively, mediation can also be ordered by the court, and this is called court-annexed mediation. There's slightly less flexibility on where and when the mediation takes place, but regardless, the mediation will be held in what we call a neutral environment. Usually, the people that attend mediation will be obviously the mediator, then you have the executor or executors of the estate, the person or persons contesting the estate, and all of the parties' legal representatives, which often includes solicitors and barristers. At the start of the session, the mediator brings everyone into the same room and then explains the mediation process and its purpose to the parties. Each party, or their legal representative, will provide their opening statement, explaining their position, and obviously everyone is listening. The parties then will go into separate breakout rooms and confer with their legal representatives in private. Then, the fun part, the negotiations start. Suggestions and offers for settlement are passed between the parties, utilising the skills of the mediator as that impartial third party. These negotiations will continue until one of two things happens. One, the parties are able to compromise and reach an agreement. Or two, the parties decide to stop the mediation session and no agreement is reached. If the parties are able to resolve the matter, they will sign a written agreement setting out the terms of the settlement and the matter will be finalised. If the parties are unable to resolve the matter at the mediation session, the matter will then proceed to the next step in the litigation process. Negotiations will continue. There may even be another mediation session. However, if agreement cannot be reached, the matter will eventually go to final hearing. But the process really is that simple. As I've said, there is a reason that mediation has been found to be so effective when it comes to settling matters. If you're facing a will dispute and you're unsure about what steps you should be taking, get in touch with us here at Turnbull Hill Lawyers. Our Contested Wills and Estates team have heaps of experience with will disputes and with mediation, and we can help make the process easier for you.